following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, the 27th of January, 2016, opened up with gold at $1,120 an ounce, silver $14.48 an ounce, Texas crude $31.45 a barrel, and Bitcoin is currently sitting at about 395 U.S. currency. Today in history, Thursday, January 27th, 1825, the U.S. Congress approves Indian Territory in what is present-day Oklahoma. This cleared the way for the forced relocation of Eastern Indians, known as the Trail of Tears. In recent news, the Vatican announced over the weekend that Pope Francis will be visiting Sweden later this year to mark the 500th anniversary of Martin Luther's writing and posting of the 95 Theses on the front doors of All Saints Church in Wittenberg, Germany, October 31st, 1517. Amongst other points, Luther primarily wrote argumentations against the Roman Catholic theology of indulgences, essentially the selling of forgiveness from temporal punishment, from sins for money, a practice still upheld by the Church. On October 31st of this year, Francis is set to be at the southern Swedish city of Lund, where the Lutheran World Federation was founded in 1947. While his predecessors have visited Protestant churches, Francis has come under criticism from traditionalists and conservatives within the Church, who accuse him of sending conflicting signals about interfaith relations. Catholic traditionalists have accused Francis of making too many concessions to Lutherans, since both religions will be using Luther's Common Prayer during the 2017 Reformation commemoration services being held jointly between the two churches, which they say excessively praise Luther, who was historically condemned as a heretic and excommunicated. Pope Francis has made ecumenism one of the main themes of his papacy, considering he has already visited the Lutheran Church of Rome, the Waldensian Protestant community in northern Italy, Rome's Jewish synagogue, and is soon due to become the first pope to visit Rome's mosque later this year. Marvin Minsky, a pioneer in the field of artificial intelligence at the Massachusetts Institute of Technology, died Sunday at the age of 88. Minsky viewed the brain as a machine whose function can be studied and replicated in a computer, and he considered how machines might be endowed with common sense, or artificial intelligence. Daniela Russ, director of MIT's Computer Science and Artificial Intelligence Laboratory, said that Minsky helped create the vision of artificial intelligence as we know it today. This was your lowdown for January 27th, 2016.
My remedy today came in a box just like they say. Okay, we are back. Randy Kelton, Groove Radio. And we survived that little dive off the cliff we made there at that last outro. And we're talking to Scott in Texas. And Scott, over the break, I pulled up your complaint against the judge. Will you kind of give us a brief on the judge and what that was about?
Well, the judge that you're looking at, that's the Addison judge.
Judge Dwight.
Yeah, that's the Addison judge. I was talking about the judge in Rockwall that I just went to.
I know. This is the complaint, the document that you wrote that I liked.
Yes.
Okay. Briefly, you went to court and had Eddie's motions filed in the court. And when you got to your allocution, your statement before the court, to explain what happened there.
Well, the judge wouldn't let me defend my motions. And as soon as I started I had an opening, basically I had a one-page document that I was just going to read that defended my points of the motion. So I was reasserting the motions in a verbal format on the record. And as soon as I started the opening sentence, when I mentioned the words engaged in commercial transportation, he started shouting, "I am not going to hear this," and shut me down and wouldn't let me speak after that, period. So
okay.
That was pretty clear.
This complaint is based on that. And this is an excellent example of how we can take these guys to task. I, Scott Richardson, being duly sworn, do state upon my oath that I have personal knowledge. I have good reason to believe and do believe. And this is how complaints are to be styled. The heading is, in the name and by the authority of the state of Texas. That's precisely how the statute requires it. And then it has in this opening sentence, I have good reason to believe and do believe. That's required. And then he starts out with some quotations, which I wasn't very happy with, but they weren't bad. I mean, the quotations he doesn't tell you why he's quoting this. And frankly, I'm picking his motion apart on really minor details. This is not really important. But the reader reads this, and he's going to read this quotation and wonder, why in the heck did he put that there? But it's a minor thing. Under our system of government, upon the individuality and intelligence of the citizen, the state does not claim to control him or her except as his or her conduct to others, leaving him or her the sole judge as to all that affects himself. Mulger v. Kansas, U.S. case. All laws, rules, and practices which are repugnant to the Constitution are null and void. Marbury v. Madison. Marbury v. Madison is a major seminal case in law, and it's very old. They didn't have the year on it here, but it's 2 Cranch, and that puts it back in the early 1800s. So it's been standing law for a very long time. And then he states the facts we just related to you. To the object of this code, this is Article 1.03, Texas Code of Criminal Procedure. The object of this code is intended to embrace rules applicable to the prevention and prosecution of offenses against the law of the state, and to make the rules of procedure in respect to the prevention and punishment of offenses intelligible to the officers who are to act under them and to all persons whose rights are to be affected by them. It seeks to adopt measures for preventing the commission of crime, to exclude the offender from all hope of escape, to ensure a trial with as little delay as is consistent with the ends of justice, to bring to the investigation of each offense on the trial all the evidence tending to produce conviction or acquittal, to ensure a fair, impartial trial, and the certain execution of the sentence of the law when declared. Article 1.04, due course of law. No citizen of this state shall be deprived of life, liberty, property, privileges, or immunities, or in any manner disenfranchised, except by the due course of the law of the land. On the 29th day of May 2015, defendant appeared at the town of Addison Court for initial hearing. Okay, this goes on to say what the prosecutor and the judge did. It explains how they wouldn't let him adjudicate his case. U.S. Constitution, Article 4, Clause 2, the Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. Okay, it goes on down more facts about how this happened on September 15th, 3 p.m. Larry Dwight held the motions hearing. You filed the affidavits, and this is where he said that Judge Dwight immediately interjected loudly. He was not going to hear this. So, where rights are secured by the Constitution, where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda v. Arizona. 105, Texas Code of Criminal Procedure. Rights of the accused. In all criminal prosecutions, the accused shall have a speedy public trial by an impartial jury. He shall have the right to demand the nature and cause of the accusation against him, and have a copy thereof. He shall not be compelled to give evidence against himself. He shall have the right of being heard by himself, or counsel, or both, shall be confronted with the obtaining witness against him, and shall have compulsory process for obtaining witnesses in his favor. No person shall be held to answer for a felony unless on indictment by a grand jury. That is Article 1, Paragraph 10, Texas Constitution, codified into law as Article 1.05, Texas Code of Criminal Procedure. Officers of the court have no immunity when violating a constitutional right from liability, for they are deemed to know the law. Murdoch v. Pennsylvania. And I charge that, therefore, and before the making and filing of this complaint. This is a compulsory language. It has to be before the making and filing of this complaint. The one thing that will make a complaint invalid and unfixable is to accuse someone of doing something after the date the complaint was filed. So this has to say on or before. Anyway, that The Texas Judge Larry D. Wright did then and there unlawfully and willfully violate Section 36.05 Texas Penal Code titled witness tampering. Scott was there to be a witness in his own behalf, and the judge denied him in his due process right to speak in his own behalf as guaranteed by the Constitution and Article 1.05 Texas Code of Criminal Procedure. The courts will say, don't bring the Constitution into my court. Okay, I don't need to bring the Constitution in your court because everything's in the Constitution's been codified into code, and we'll bring the code into court. That the judge has to pay attention to. Have you filed this yet, Scott?
No, because you said that the opening statement, that we wanted to work on that and make it, because you said it didn't really fit. Okay,
I didn't think you did, because there's a little bit more to just that opening. We needed a little bit of a preamble to explain why this opening case law is in there, and then this thing is good to go. The judge is not going to be happy when he sees this, and I like this one because he's filing criminal charges against the judge for raising his voice. Witness tampering is a felony in the state of Texas. The judge raised his voice for the specific reason of preventing Scott from exercising a right. Let's see how that works out for you, Bubba. Now, this should definitely get a judicial conduct complaint, but also criminal. This is a crime. I mean, judges don't get to commit crimes. They're not immune from the same law that everybody else is subject to. So, early next week, we get these things filed?
Yes, sir.
And the way he's going to do this is a Dallas County. The offense was committed in Dallas County. But he's going to take it to Tarrant County. It's a test. I took a set of complaints against the Dallas County District Attorney to Tarrant County. And the District Attorney stood aside. But then again, I had given this District Attorney the law, and this District Attorney hated Craig Watkins. And the new District Attorney in Dallas County hated Craig Watkins. So there was a definite political element. What I want to see is if they interfere with Scott. Because if they interfere with Scott, then we come after him. Then I get to go in and hammer them for that. So we want to get this grand jury pried open so that we have a place we can file criminal complaints. Now, the complaints I filed against Craig Watkins went to the grand jury, and I got a letter from the foreman of the grand jury, and it said that under Article 20.06, it was the duty of the grand jury to investigate into all crimes subject to indictment that come to their knowledge by any grand jury member by way of the prosecuting attorney or any credible person. So I was that credible person. Credible person, term of art. Credible person means in law a person over the age of 18, never convicted of a felony. So I met that requirement. I was by law a credible person. I gave them notice. He went on to say, we examined into your complaints and found no Tarrant County offenses subject to indictment. Is that a fact, Jack? What part of all offenses is hard for him to understand? Okay, Scott, what's the crime he committed?
The crime was witness tampering.
Nope. Hold on, about to go to break. We'll pick it up on the other side. We'll be right back. Now.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Well, don't let nothing get to you. Only the Father can deliver you. So don't let bad mind people hurt you. Until Satan get behind you. Know what I mean? My friend. And all of your children, come. Those things that hurt me free.
Okay, we are back. Randy Kelton, Real Radio, and we're talking to Scott in Texas. And no, not witness tampering. No one interfered with me at all. They let me come down there and give the complaints to the bailiff, and he took them to the grand jury.
But wouldn't it be more official oppression, actually?
Ta-da! Exactly what it would be.
Yeah.
He failed to perform a duty he was required to perform, and in the process denied me in the full and free access to or enjoying my right to petition court for redress of grievance. Class A misdemeanor in the state of Texas. Perfect. So I'm going to take that to the Texas Rangers. We had someone take a complaint to the Texas Rangers, and this is after the Texas Rangers have met their statutory requirement to set up a protocol for investigating public officials. And one of the protocols they established was they go to the prosecuting attorney and ask the prosecuting attorney's permission. So we're going to see how that works out for them. I will file with the Texas Rangers a complaint against the foreman of the grand jury for secreting complaints against Craig Watkins from his own grand jury. And we'll see if the Texas Rangers goes to the prosecuting attorney and asks the prosecuting attorney's permission to investigate this. I think I understand where this comes from. Prior to this new law that was just passed at the last legislature, the Texas Rangers could not investigate a public official. They couldn't take a complaint against a public official and couldn't even investigate a public official without the written permission of the director of the Department of Public Safety. Now, I take that as criminal on its face. And they appeared to have brought that restriction now and brought it to the prosecuting attorney. And here's the problem. Article 2.03. Article 2.03 says that when a prosecuting attorney is made known, and I'm paraphrasing here, it's a little long and complex, is made known in any manner that a public official has violated a law relating to his office, he shall reduce complaint to an information submitted to the grand jury. So the prosecuting attorney is forbidden to investigate crimes against public officials. They have no discretion. They must get it to the grand jury. So if the Texas Ranger come to the prosecuting attorney with a complaint against a public official, and the prosecuting attorney says something that keeps the Texas Rangers from investigating the complaint, since the prosecuting attorney has been forbidden to have anything to do with that, then I'm going to call that obstruction of justice. See how that works out for them. Now, Article 4, the Government Code 411, which sets up the Texas Rangers as having authority to investigate public officials, directs the Texas Rangers to work with the prosecuting attorney. And what I'm going to say is you can work with the prosecuting attorney all you want to, but you can't interact with the prosecuting attorney in a way that amounts to a violation of law. And asking the prosecuting attorney's permission to investigate a public official would cause the prosecutor to violate Article 2.03, which would amount to a felony obstruction of justice. So you can't work with the prosecuting attorney in a way that violates law. So this is early on in the game. They're just getting things set up. If this works out right, I will get the Texas Rangers completely separated from the prosecuting attorney in matters of complaints against public officials. And so the Texas Rangers can act on their own and not be subject to prosecuting attorneys, because that puts us right back where we were. The problem here was you try to file a complaint against a public official and a prosecuting attorney would exercise prosecutorial discretion. And that's exactly what she did in a family law case. So we're going to get those folks in the family law case to file a complaint against Sharon Wilson for obstruction of justice, because she refused to allow the Texas Rangers to investigate judges in Tarrant County. We see how that works out for them. Does that make sense, Scott?
Yeah, so it almost sounds like whenever we start having criminal complaints, we can almost take them to the Texas Rangers.
Not until we get the Rangers set up. That's why I'm taking them the grand jury foreman complaint.
Well, yeah. Well, it's kind of good because we need to bust up these grand juries anyway, especially if they're, sellouts. And
No, hold on. There is no problem with the grand juries.
None?
None. Not as far as I can see. There's no problem with the grand jury. This was not a problem with the grand jury. This is what I think happened. I had already demonstrated to Sharon Wilson that while a district judge who impanels a grand jury has a venue restriction, they can only hear cases within a venue. For instance, Tarrant County, all of the district judges in Tarrant County are restricted to offenses that occurred in Tarrant County. And that judge impanels a grand jury. But there is no statutory venue restriction for a grand jury. So the grand jury assumed a venue restriction. They knew they were impaneled in Tarrant County, so they assumed that they only had jurisdiction for Tarrant County. And since the prosecuting attorney had stood aside, and I made it clear that I was aware of 2.03 and expected them to abide by it, good chance that the prosecuting attorney stood back from the grand jury, did nothing. So the foreman couldn't ask for advice from the district attorney, so he went to the judge that impaneled the grand jury. And that judge says, oh, no, that's Dallas County. That'll have to be filed in Dallas County. So it is my belief that the foreman, who is essentially a legal novice, did not make this up, but acted in good faith reliance on competent authority, and that is the advice he received from the judge. And here is the judge's problem. When can you not sue a judge?
When he doesn't have jurisdiction.
No, not sue him. You can't sue him when he's acting in his capacity as a judge.
Right.
What capacity is he acting in when he gives legal advice to a governmental agency? That's not a judicial capacity. Now he's acting as a lawyer. I can sue him for that. I think this was a female, but I sue her for that. So when I file criminally against the foreman of the grand jury, then I expect that the foreman of the grand jury will throw the judge under the bus. The foreman will say, well, this judge told me to do that, and I acted in good faith reliance. The foreman of the grand jury was not a legal professional, so they can claim good faith reliance. Public officials can't claim good faith reliance under the Scrooge Doctrine. If a public official violates a ruling of this court and he be sane, he may not be heard to say he knows not what he does. Now, a private citizen can't claim ignorance of the law, but we can claim good faith reliance on competent authority. If I go to a lawyer and he says, oh, yeah, this is legal, you can do this, that is an affirmative defense to prosecution. But a public official can't do that. So I'll nail the foreman in order to keep me from hammering the foreman. And I'm hoping they'll throw me this judge, and then I get to sue the judge. That should be interesting. Hang on. Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. We'll be right back.
Attention foreign language students, hit the books and get out those dictionaries. There's major good news about learning a second language. I'm Dr. Catherine Albrecht, back to tell you about a new study on bilingualism after this.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Learning a foreign language brings many benefits, but a new study has found a major long-term health benefit to bilingualism. It may delay the onset of Alzheimer's. Canadian researchers reviewed hospital records of patients with dementia. They discovered that bilingual people were diagnosed 3 to 4 years later than those who only spoke one language, even though they had less education and job status. Though brains of bilingual people still develop Alzheimer's, the scientists said, speaking another language better prepares their brains to compensate for the onset of the disease due to the enhanced brain networks they've developed. Maybe it's time to brush up on that French, n'est-ce pas? I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Live Free Speech Radio, LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Boulevard Radio, and we're talking to Scott in Texas. Okay, that's kind of the plan for Tarrant County. And then the next thing we want to do is go to Dallas County. Now, the district attorney for Dallas County hated Craig Watkins. But, and that was part of what eased the way for me filing criminal charges against Craig in Tarrant County. But now I want to take those same criminal complaints back to Dallas County because the new district attorney, they were trying to get her removed from office, but I think all of that has kind of died down. So things have kind of smoothed out for her in Dallas County. Now I'm going to take her complaints against Craig Watkins. And the complaints against Craig Watkins are that I went down to the grand jury in Dallas County and was denied access to the grand jury by investigators for the Dallas County District Attorney's Office. And those Dallas County District Attorney's officers, investigators, were wearing or prominently displaying deadly weapons. So I'm accusing the Dallas County District Attorney of first-degree felony aggravated assault. And Scott's familiar with this one because that's what he's charging the police officer with. He was arrested. He broke out his window, threw him in jail. And because he wouldn't ID, not ID, failure to ID was the basis of the arrest. Problem. The only time you have to ID is once you've been arrested. So he had to be arrested for something else first. There was no pre-existing warrant. So there had to be a different offense for which he was arrested. Then he had a statutory duty to ID, but there wasn't one. So when the officer made the arrest, he was prominently displaying a deadly weapon. And when he broke out the window with a billy club, that was assault. At very least, it was simple assault. But he broke out the window, he splattered glass in Scott's face. So that was offensive touching. And it was offensive in a way that could have caused serious bodily injury. What the code says, that if someone commits simple assault as defined by 21, Section 21, the penal code, I think it's 2102, 2101, I don't know, whatever, and he is prominently displaying a deadly weapon, and that's felony of the second degree. Unless he is a public official acting under the color or pretense of an official capacity, in which case it's a felony of the first degree. 20 to life. You want to play hardball, Bubba? We'll introduce you to the deep end of the pool. Now, the likelihood of getting Craig Watkins indicted for first-degree felony aggravated assault because his officers escorted us out of the courthouse while prominently displaying deadly weapons, the likelihood of getting an indictment is somewhere between little and none, and we don't care. What we want is for Craig Watkins to have to consider the prospect. About 5 years ago, I went to the Travis County District Attorney with Travis County Grand Jury with criminal complaints against all the 15 judges of the Court of Criminal Appeals. We're in Texas. Texas has two high courts. We have a Supreme Court that handles only civil issues, and we have a Court of Criminal Appeals that handles criminal issues. Both of those are courts of final jurisdiction. So they're the highest courts in the state. Well, I filed a habeas corpus for a kid in Conroe, and that habeas corpus is on my jurisprudence website. And the Court of Criminal Appeals demanded that I include a motion for leave to file. And I told the clerk, heck with that. This is a habeas corpus, a great writ, a writ of right. This court has no power to grant or deny leave. Well, he wouldn't take it without the motion, and they're trying to get this kid out of jail, so it's not my fight. I filed the motion. The court denied the motion. So I immediately filed Class A misdemeanor official oppression, claiming that the Court of Appeals exerted or purported to exert an authority they did not expressly have, and in the process denied me full free access to enjoyment of my right to petition court for redress of grievance. 11.51 specifically authorizes, it references filing of a habeas corpus. The habeas corpus may be filed by the principal I think it says principal, whatever he is, by his counsel, the defendant, may be filed by the defendant, by defendant's counsel, or any credible person. So anyone can file a habeas corpus for anyone in Texas. So I had standing to file it. And then when I went down to file it, acting under my authority under 11.051, the Court of Criminal Appeals denied me in my statutory right to file it. Violation of 3903 Penal Code. I tried to file it. The district attorney interfered. Claire Dawson Brown, for the Travis County District Attorney's Office, intercepted the complaints and did not give them to a grand jury. So I came back. And this time I had a camera crew with me. And told the bailiff. Bailiff was a sweet little old lady. I told her that my name is Randall Kelton. She said, yes, Mr. Kelton, I remember you. Instruct the foreman that I have business with the grand jury. She said, may I tell him the nature of the business? Yes, you may. Give him these. I gave her a stack of 13 folders that were all about an inch thick. And she picks up the phone and makes a call. And I said, ma'am, are you calling the district attorney? She said, yes, I am. I needed to get some legal advice. I said, that's not a good idea because those complaints are against the district attorney. Oh, and then the phone's in her ear and she said, he said these complaints are against you. And then in about 5 minutes, Claire Dawson Brown shows up and she's got 2 women with her. One of them looks like a clerk or secretary, and the other one's in uniform with a pistol. And when Claire came out, I held up both hands with my palms out, and I said, Claire, you can't be here. And this, I guess she was a security guard, she stepped forward, because she wasn't in a Tarrant County Sheriff's Deputy's uniform. She stepped forward, and she said, is there a problem here? I said, yes, ma'am, there is. I'm here with criminal accusations against Claire Dawson Brown here, accusing her of secreting criminal complaints from all the highest judges in Texas from a grand jury. Are you going to interfere with me? And she held up both hands with her palms out, stepped back. Nope. So still didn't get him to the grand jury. So I bushwhacked Robert Perkins. He was a head criminal district judge for Travis County. I bushwhacked him in his courtroom. He's having motion hearings. And I come in, I always wear a nice suit and tie. I walk up to the bench and stand there, or to the bar, and I just stand there. And the bailiff finally looks over, and I pointed at him, you, come here. Oh, he hated that. Because generally lawyers come in there, and they're timid little mice because they're terrified of the court. So the bailiff comes over and says, may I help you? My name is Randall Kelton. Instruct the judge that I have business with the court. Bailiff says, may I tell him the nature of the business? No, you may not. I have business with the court, and it's none of yours. You're dismissed. I go sit down. Now he is furious. So he finishes, he runs up to the judge and jibber, jabber, jibber, and the judge jibber, jabber, jibber. And the judge finished his hearings, his motion hearings, and Mr. Kelton, I understand you have business with the court. Now, I hold up this red folder. Yes, Your Honor. As a matter of fact, I do. May I approach? And that means, can I give you these documents? Generally, they'll send the bailiff to get them, but this time he said, well, come on up. So I came up and handed him the documents. He opened them up. He's looking at criminal charges against the district attorney for secreting criminal charges against all the highest judges in Texas from a grand jury. Hang on. Randy Kelton, Rule of Law Radio. I'll be right back. Okay, we are back. Randy Kelton, Rule of Law Radio. And I was talking about Bob Perkins. Bob Perkins is really a generally nice guy. I liked Bob Perkins. But when he opened that folder and looked at who those complaints were against, you could see that his whole career passed before his eyes. And I won't go through all the back and forth we had, but he finally directed me to give the complaints to the district clerk. And once that happened, the district attorney's position changed. I went back to Claire Dawson Brown to get my complaints back from her so that I could take them back to the grand jury. And when she brought them out, I told her, I said, Claire, you know I filed charges against you. She said, yes, I know. I said, I don't want to do that. And if you would just take these complaints and give them to the grand jury. Since you have no option under law, you don't have to agree with it. So you're perfectly authorized to go in there and argue against indictment. That way, everybody wins. I don't really want these guys indicted. She said, well, then why are you filing this? Well, I don't want them doing what they were doing anymore. I just want them to follow law. And I'd be fine with that. And she said, well, Mr. Kelton, give them back to me. I'll talk to my boss. She gives them to the grand jury. So the grand jury gets them the first day in office. They're in office 3 months. This is 1st of April they got it, appropriate day, April Fool's Day. And then in the middle of May, I went to her and said, what's going on here? It generally takes them 20 minutes to do an indictment. She said, Mr. Kelton, I made sure every grand juror read your entire presentment. Say what? That thing was 111 pages long. My habeas was in there. And I've come away from that wondering, what in the world is going on here? And then it occurred to me, Ron Earl, 25-year district attorney, he's retiring, he's not running for office again. He's the guy that took out Tom DeLay, and he did it illegally. He's a Democrat. All 15 of these judges are Republicans. Everything is political, and all politics is local. This had nothing to do with law. It had nothing to do with me. It had everything to do with politics. Where you and I have our power is not in getting someone indicted. Where we have our power is creating cannon fodder for political entities, political enemies. I gave Ron Earl cannon fodder to try to get all these judges taken out of office with him, and he almost got them. The grand jury held my complaints until their last day in office and then no-billed. If you go to file a habeas corpus with the Court of Criminal Appeals in the state of Texas, you will not be asked to file a motion for leave to file. They cut that stuff out. This works. So taking these guys on, filing these complaints against them, this works. Now, I'm sure those highest judges in Texas felt like they wouldn't be indicted. However, they could have been, and there was nothing they could have done. And they knew that Ron Earl was doing everything he could to get them all indicted. Who would want to play Russian roulette with their career? Fighting with the grand jury is where our power is. And just fighting to get to the grand jury is very powerful. So, Scott, we take that complaint first to the Tarrant County District Attorney, and if they do anything to interfere, you can't go to Tarrant County effectively and file criminal charges with the district attorney against the district attorney. Well, that don't make sense. So when the district attorney interferes, you take criminal complaints against that district attorney to the one in Dallas County because the grand jury has no venue restriction. Take what they're doing and cram it down their throats. And this particular maneuver gets you high up on the pecking order real fast. Now just consider that local municipal judge back there watching you trying to get the Tarrant County District Attorney indicted for not indicting that podunk judge. How do you think that judge is going to feel?
Oh, yeah. I mean, this is going to get real squirrely with a lot of people. And speaking of Dallas County, next week I get to go meet in front of Tina U. Clinton for the actual driving invalid, which was what Addison charged me for after he put me in jail. So, and she's a little bit meaner over there because Dallas County, they like to run on pure fear and intimidation. And I don't even know why I'm there because the last time I was there, it was just to pick on to deny their free attorney because I'm representing myself always from here on out. But I don't.
Okay, hold on. You said you don't know why you're there.
Yeah.
Did you receive a summons?
Huh? Did
you receive a summons in order to appear?
Well, I'm rescheduled, and it's for an announcement, and I'm still, she's like, well, you don't get any help with this court.
Okay, hold on. Read Article 28.0 28.01 Texas Code of Criminal Procedure. Texas, the 28.01 lists all of the things that a judge can order you to come to court for. An announcement that's not listed in there. So, what do you do in that case?
That's what I don't understand.
Official oppression. Judge ordered you to come to court under his authority as a judge. 28.01 tells him exactly what he can order you to court for. Now, an announcement is not listed in there. So he's exerted a purported exerted authority he does not expressly have, hammering for it. That's Class A misdemeanor. That hammer you. Now you file against the judge and move to disqualify.
Well, see, and it's so weird because they make you fill it out yourself. I mean, she's like, you go fill this piece of paper out, so you have to kind of check it off yourself. She doesn't make you.
No, you missed it. It doesn't make any difference who checks what. You were ordered to be in court on this day at this time. There are only certain things they can order you to be in court on. An announcement's not one of them. I nailed the Travis County Court when they gave me a summons to be in court, and I get there and I asked the judge. I said, "Your Honor, I have this order to be in court here today, but it doesn't tell me why I'm here. You want to tell me what I'm doing here?" "Well, Mr. Kelton, we needed to find out if you had an attorney." "Well, that's interesting, Your Honor. I have 28.01 Texas Code of Criminal Procedure, and it lists all those things you can order me to come to court for. To see if I have an attorney is not one of them." And that was great fun. But this judge happened to be Ron Earl's daughter. And I'm acting always from the position that you will never win your case simply because you have the law and the facts on your side. You'll win the case if you have the politics on your side, and all politics is local. So as politics go, she was probably the most political-minded judge I could have got, since she was Ron Earl, the ex-district attorney's daughter. So I kind of backed off on her. But I could have filed official oppression against her. That's a crime, exerting or purporting to exert an authority you don't have. If you hadn't shown up that day, you'd have been arrested. If you don't show up on the day you've been ordered to be there, they'll arrest you for failure to appear. So prepare a complaint for official oppression. Take it with you.
Yeah. I mean, I have blank ones I could just sit and fill out right then and there. The only thing that kind of makes a person a little bit nervous is you don't want to file something and then they say, "Oh, you filed the wrong thing, and now we're going to hammer you for that."
No, this is a criminal complaint. If they say one word to you that you can anyway construe as being threatening or intimidating, what's that one?
Threatening or intimidating, that would be official oppression.
No, much worse than that. Okay, you're filing a criminal complaint. If they say anything to you as a result of your filing that criminal complaint that you can anyway construe as threatening or intimidating,
that's obstruction.
Obstruction and witness tampering. Both of them felonies. The water gets deep really fast when they start playing fast and loose with authorities they do not have. So you guys want to play hardball, we'll take you to the deep end of the pool. So you make out the complaint as if it has already happened. So that once it does happen, you got it in your hand, Mr. Bailiff. I need you. Bailiff comes over. I need you to verify this criminal affidavit in accordance with your authority as a certified peace officer in the state of Texas. And he's going to read it. It is criminal charges against the judge for official oppression for ordering you to come to court when she didn't have authority to do so. Hang on, Randy Kelton, Rule of Law Radio, or call-in number 512-646-1984. We've still got an hour to go, and we had a caller from Georgia. If you will call...
Story for everyone to hear about how we're not gonna give in to the fear. Yeah, it's a story. I will lie by my father's house till he returns. I will lie by my father's house. He has
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Scott in Texas. So, if you file criminal charges against the judge, have you already filed a recusal motion on the judge? Oh, we can hear you easier if I unmute you. Okay, sorry, I had you muted there.
Well, what I was going to say is, should I go ahead and prepare a criminal complaint for dragging me to court for just asking me if I was going to take their free lawyer or not for 28.01 and go ahead and have that? Or
yeah, that's the one you want, already prepared. And when you ask her why you've been ordered to court and she gives you a reason that's not included in 28.01, then you already have the document prepared. You call the bailiff over, tell him you need the bailiff to verify your signature, a criminal complaint against the judge.
Would I go ahead and forward the one that I was already there for? Could I go ahead and file a criminal complaint on that? Because I don't even know why I'm going to this one coming up. I don't even know what the hell's going on.
What was the purpose of the other one?
The other one was just to see if I was going to take their free lawyer, the court-appointed attorney. That was it.
Okay. File one for that as well.
That's the one because see, that one now I know I have precedent because it's already happened. I can already make the complaint. All I need to do is get the bailiff to witness my hand.
Oh, no, wait a minute. Let me tell you a little story about Ken Magnuson.
Okay.
Ken Magnuson is in court, and he had filed a motion in court that he knew they were going to deny. When the judge denied the motion, he stood up and said he had a document to present to the court, and the bailiff came and got it and gave it to the court. The court looked at it, and it was I forgot exactly what the motion was, but it was because the judge had just rendered that ruling. This is why he filed this one. And the judge looked at it and said, "Well, Mr. Magnuson, it seems you were a step ahead of the court." And Ken holds up 3 fingers. Yeah, we're ahead of you. That's the point. You want the judge to know you were a step ahead.
Right.
That you knew what he was doing was improper, and you didn't give him legal advice. You let him walk right into it, and then you zapped him with it. So you take the old one and you take the new one, and you file 2 against him. And he'll tell him that you were prepared for him, and essentially you set him up for it. See, they expect you to come in and give them legal advice. Oh, I got my rights. You can't do this. You can't do that. No. Don't do that. Never ask public officials to do anything you actually want them to do. Because you never ask them to do anything that the law does not specifically command them to do. And when they don't do it, you get to zap them. And then it'll become clear to them that everything you're doing is a setup. Everything you're doing is about getting a way to come after them. And you're doing it in ways that they can't defend against because they have been following a policy that has been established for a very long time. Problem is, the policy is illegal. Lawyers aren't going to complain about it because they don't want the judge upset at them or the court's upset at them because they're in the court dangling by their bar card. You are not.
Yeah, it's really empowering. So once you kind of, start knowing where you can really start asserting your power over these people and holding these people accountable, I mean, you start turning into we're the judge killers now. I mean, the cops, they're just the order takers. They're out there writing people tickets and stuff, but the judges are letting these courts get away with it, and that's where we have to put the stop to it.
Exactly. I always say that if you don't know where you're going, there's a good chance you'll wind up somewhere else. Well, I have an intended outcome in mind, and it's always in front of me. It governs everything I do toward the courts. It is my specific purpose to place every judge in the country in a position such that when the judge steps up behind the bench and looks out across the bar at the gallery, I want him wondering, which one? Which one of those scoundrels out there in the gallery are waiting for me to render a ruling he don't like so he can run down to the grand jury and try to get me indicted? When our jurists stand up behind the bench with that in mind, we will begin to have justice. And we can do that. It's not so hard. You hear me spouting all these codes? Well, if you listen close, you'll find I'm not spouting very many codes. Half a dozen, maybe 10. That's not a lot to learn. And once you got them, well, these guys got a problem. 3903 is probably a key one. 3903 Penal Code is a catch-all.
Yeah.
Anything they do that they're not specifically authorized to do, you can nail them for it. For the most part, our public officials don't understand that they are the servants, we are the masters. We can do anything we want to unless I and my fellow masters have gotten together and decided that we would limit ourselves in this regard. We have limited ourselves in that we agree not to kill one another. We agree not to rob from one another. And there are a number of agreements that we have made. We've agreed to certain restrictions on our own behavior. Other than those specific restrictions, we can do anything we want to, unlike public officials, who may only do what we have specifically authorized them to do. Like this judge raising his voice to you, we did not authorize him to do that. We did not authorize him to deny you in due process. We did not authorize this judge to call you, to order you to come down to court on threat of arrest for just anything he wanted to. That's not in the book there. So he's exerting or purporting to exert one he doesn't have. And we've called that a criminal act. Class A misdemeanor, you're in jail, up to $10,000 fine. We considered it a serious offense. And if a public official purports to exert authority he doesn't have while prominently displaying a deadly weapon, that's a first-degree felony. That's right up there with capital murder. Our legislators considered that to be an incredibly serious offense. These cops do it all the time. I did a search on Lexis and Westlaw. 2202 B2A and B. Now, B2B makes it a first-degree felony to commit assault against a public official while you are displaying a deadly weapon. Doesn't matter if you use it or not, just displaying it while you commit the assault. Now, when I did a search on that one, I got 30,000 hits, and that was the maximum hits I could get. When I did a search on 2202 B2A, assault by a public official, I got 0. Now, let me tell you how inclusive that is. I had a guy in Austin. He's since passed away, but he was a real stinker. And I was helping a friend of mine who's a clinical psychologist. I ran a search on this guy on Lexis. I ran his name on Lexis, and I found every single suit he had ever filed. JP courts, everything. So when I ran this search on 2202 B2A, I got everything that had been filed on that particular statute. Nothing. We were at a hearing. Eddie Craig's the one that spoke, but he spoke on this statute. This was a hearing where there was a group trying to get 3903 Penal Code increased to a felony if there was bodily injury, because the police had chased a 16-year-old boy. He gave up, laid down, and 6 police officers ran up to him and kicked and stomped him for 1 minute and 20 seconds. Now, that is a really long time. Don't sound like it, but you're down there being kicked and stomped on. That is a long time. So the neighborhood, this is Houston, was outraged. And we're at this Senate subcommittee hearing, Senate or House, well, I don't remember which one, on this issue. And the district attorney from Harris County stood before the legislature and told them that the only thing he could charge these officers with was 3903 Penal Code. And Eddie got up there and just read them the riot act. He pointed over to this lawyer. He stood up here in front of you, and he looked you in the eye, and he lied like a dog. He pulled out about 2202B2A. They got real quiet in the room as Eddie read them the riot act. But it did get the provision passed. Now if a officer assaults you when he doesn't have authority now and hurts you, now it's a felony. So you may be able to claim that one against this officer who broke out your window. Well, you don't need to. He's got a loaded pistol, and you can do 2202B2A. That's what you've already done. So good chance eventually we'll get an indictment on one of those. But even if we don't get an indictment, just accusing them of a first-degree felony, that's going to terrify them, especially the police, because they feel like they're used for cannon fodder. And that's politics. I'll explain a little of that politics when we come back. The police and the municipal and justice of the peace judges feel like they're used for cannon fodder, so they feel vulnerable. I'll explain how when we come back. Randy Kelton, Groove Law Radio, or call-in number 512-646-1984. We'll be right back.
This is the Logos Radio Network.
Oh, come on.
Okay, we are back. Randy Kelton, Groove Law Radio, and we're talking about the politics. Justice of the peace judges and municipal court judges are generally are defined as inferior court judges, because for those positions you don't need to be learned counsel. You don't need to have a bar card in order to be able to serve in those positions. A lay person can do it. So they call those inferior courts. And it is the belief of justices of the peace and municipal judges that the State Commission on Judicial Conduct is primarily a public relations agency for elected judges and superior court judges. They never discipline the county and district court judges. That's what these guys believe. And that they use JPs and municipal court judges as cannon fodder to make it look like they're actually doing something. And that is true. That's exactly what they do. So municipal judges and JPs, they really worry about judicial conduct complaints. Police officers. The only... about every time a police officer is hammered for whatever reason, he's generally hammered big time. But this is what the police tend to perceive. What they don't realize is it takes an awful lot to get the system to come after a police officer, because they just almost will not do it. When they come after a police officer, he has to really be a stinker. He has to be a major problem and embarrassment, and they come after him to get rid of him because they just can't protect him anymore. But the only ones they see the system coming after really get hammered big time, so they excuse me there. So they tend to think that if the system comes after me, they're going to crucify me. In fact, the system will almost never come after me. And I got proof of that. But anyway, that's their fear. That's the reality they live in. The policemen really feel caught between the system and the public. And they are. They're right. They're trained to act in a way that serves the public officials because they collect a lot of money. But being trained in acting that way puts them at odds with the public. So the policemen really are. They feel like they're stuck in the middle, and they're right, they are. And I'm not here feeling sorry for the police. They chose this profession. If the profession has difficulties, every profession has difficulties. Deal with it. But the police feel like they're in a special position because they have to run around with guns on and catch the bad guys. Well, give me a break. Nobody twisted your arm and forced you to become a policeman. This is your chosen profession, so don't whine about the conditions of the profession you chose. I'm not sensitive to their whining and crying. I expect them to do their job. If it's hard, it's hard. If it's easy, it's easy. Just get it done. If you can't do it, then get out of that profession. There are plenty of people waiting in line to take your place. So, point is we can use the politics of the situation to help change things. Where we have justices of the peace and municipal court judges going to state-sponsored and accredited training, and where we have police officers going to TCLOS, that's the oversight agency for the police, where we have the police going to accredited training and schooling that schools the police in practices and procedures that are absolutely illegal. This is something we need to handle. So we need to understand the politics. The system, the state, is training the police officers to act in ways that are illegal. So how do we fix it? Well, one way was we put the policemen in a position to where they tell the state to go scratch. The policemen feel like they'll be thrown under the bus. Well, let's throw a few under the bus. Let's go after them for doing what the state directed them to do. This is what I've been doing for a long time. I try never to file a complaint against someone for doing something personal or individual. I once had a bailiff push me out the courthouse door and knock me down. As I stepped out the door, he gave me a little push, just as my foot hit a carpet they had there to clean your feet on. And that thing went out from under me, and I fell backwards, landed on my elbow on a marble step and broke my elbow. I didn't go after the officer. That would have ended his career. And I'm going to end a human being's 20, 25-year career over a minor indiscretion. He didn't try to knock me down or push me hard at all, just a tiny little nudge. And boom, down I went. He was flabbergasted that I fell down. But he did have his hand on me when I fell down. That would have ended his career. I'm not going to end this guy's career over that. Besides, I had to sit back and look at it and ask myself, how will this lead me toward my stated intended ultimate outcome? And I could find no way to craft going after that officer in a way that would lead me toward putting the judges on notice. So I just could not. And that got me more credibility than anything I could have done. All of a sudden, they realized I was the real deal. That I wasn't just coming down there to hammer them and give them a difficult time. That I would go through this kind of difficulty. You ever had a broken elbow? That son of a gun is really, really painful. That I'd go through this and not raise an issue just to protect this guy's career. This is how we get it done. We keep our focus. But if the officer did something that was in keeping with his duty, that's following his training, and he does it, and what he does is illegal, I love to go after him for that. I was at the Tarrant County Courthouse, and I called 911. I need you to send an officer out here. Well, what's the problem? I need you to arrest these two guys at the metal detectors for following policy. The guy said, what? Yeah, I need you to arrest them for following policy. Well, what did they do to you? Well, they wouldn't let me go in the courthouse because I didn't volunteer to go through the metal detector. Well, what's wrong with that? It's illegal. Well, that's their standard policy. I don't care what it is. It's illegal. So I'm accusing them not of doing anything malicious or intentionally harmful to me, but following a legal policy. And I explained to the dispatcher, look, this is an issue we've been wanting to take on, but I can't take on an issue unless I've been harmed by it. I need this complaint file so that I can show I was harmed by the policy. I don't want to do any harm to these officers. That's the way we get the system changed. We accuse them of following policy and sting them for following policy. Now the officer said, what is going on here? This guy's trying to get me indicted because I did what the boss said. So when the boss comes back out and tells him to do that again, he's going to tell them, heck with you. You go out there and do that. This guy's going to get me indicted. Oh, my goodness. My call lines are filling up right here at the end. So, Scott, if I kind of used you up.
Yep, you're good.
Then I'm going to drop you like a hot rock.
All right, bye.
And thank you. Scott, we got Spencer and Larry. I see you guys there. We're about to go to break. Spencer, we'll get to you when we come back. This is Randy Kelton, Louisville Radio. Our call-in number 512-646-1984. And during the break, you might go to our Logos Radio Network and look over our gun giveaway for the drawing this year. And we're trying to raise funds to keep this going. Help us out.
If you were hiding from the law, would you answer an ad promising a free TV to anyone who tested home electronic equipment? Some Chicago crooks did, and police gave them quite a prize. I'm Dr. Catherine Albrecht, back with details after this.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Con artists love scamming people with bogus offers, but in Chicago, police turned the tables and reeled in dozens of arrests. Police mailed invitations to the last known addresses of 10,000 violent felons, drug dealers, and burglars, offering $75 and a free plasma TV to anyone who came down to a warehouse to test out TVs and video games. Inside the warehouse, decorated with party balloons and posters, officers in bright T-shirts had those gullible fugitives pose for pictures before arresting them. 102 in all. I'd say even Paul Newman would have gotten a chuckle out of that sting. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Actually be kidding about chemtrails.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
I see two. The evidence I see tools of ingenuity, the use against the workers of iniquity.
Okay, we are back. Randy Kelton, Louisville Radio, and we're going to Spencer in Idaho. Hello, Spencer. What do you have for us today?
Hey, Randy. I just wanted to, blow off a little steam here and fill up a little bit of your time. I was initially calling because I had gotten stopped for a traffic citation while I was busy listening to you there. I had an absolute heyday with the officer there. I was a little bit rude to him. I stopped him, asked him what the emergency badge number, proceeded to let him know I'm not operating commercially. He agreed. Yeah, I never accused you of operating commercially. And then I said, you're accusing me of speeding here, And he's like, that's right, I am. And it's like, so what actual crime are you arresting me for? It's like for speeding. So we got into it there. He ended up there was about six cars that he had to call for backup, and I asked him what he was afraid of, what he needed all those people there for, and he stated he simply didn't trust me because I was not complying. It got really interesting there, but ultimately, he wrote me a citation and sent me on my way. I just left about 2 or 3 minutes ago, just before the break. But I wanted to know your thoughts there.
Okay, I'm not familiar with Idaho traffic code, but has Idaho adopted the federal transportation code?
That I couldn't say. I'm honestly traveling through here. I'm from out of state. So I don't know their laws just yet.
Oh, okay. That makes it a lot more difficult. If you look at the code, there may be a trick. Since you are from out of state, and if you look at their code, and their code is similar to our code, in Texas we have adopted the Federal Transportation Code. And most states have. And that was promoted so that the traffic laws would be relatively consistent. If Idaho has adopted the Federal Transportation Code, then the commerce issue is well-founded, and you have been denied in due process. That you can take to a federal court.
Yeah.
And not in Idaho, but where you live. So you remove it to a federal court and make a claim of due process violation, And you put them in the position they want to put you in. They want you in a position to where it costs more to fight the citation than it's worth. You want them in a position to where it costs them way more to fight you than it's worth.
Yeah. I haven't looked at the laws. I don't know what they are here.
What state are you out of?
I reside in Washington. That's my residence.
Oh, okay. So you could drag them up to Washington State or to a federal court in Washington State. They have to hire a lawyer in Washington State to deal with your due process claim.
True, yeah. And that would be more expensive than I assume it wouldn't be more than $100 or a couple hundred.
Couple hundred bucks to file a lawsuit, about $250, I think.
Yeah, and for them to get a lawyer, they're looking at thousands or more.
Big money.
Yeah.
What you might consider doing is a tort letter to the city. Before you sue a governmental entity, as a rule, you have to give them a notice and opportunity. And most municipalities or most governmental agencies require that you give them 60 days notice. Most states have that law. And that's great. Tort letters are great. So you accuse the officer of a due process violation, a federal due process violation, and maybe make a claim against them for a pretty decent amount. And you tell them that you have been harmed, to make me whole, to be sued. So if they don't want to go to the federal court, and if you note in your tort letter a federal due process violation, then if they don't want to go to court, they may just dismiss your case. It's just about the money anyway.
It is. They want the money. They got me one for not having proper registration.
Hold on. Is your automobile or your conveyance registered in the state of Idaho?
No, my vehicle is not. Well, we don't necessarily want to call it a vehicle here.
Call it that four-wheel thingy. If it's not registered in Idaho, it's not any of Idaho's business how it's registered.
Exactly.
So Idaho is charging you with violating a Washington state law. That is a constitutional due process violation.
Yeah.
Oh, that's wonderful. You never interfere with somebody when they're screwing up.
Yeah.
So that's just a not very smart cop. When I first moved to Texas from Illinois, I had this van, and this cop pulled me over. This DPS pulled me over. And he said, Mr. Kelton, I see you have Illinois plates on. I said, yes, I do. He said, Mr. Kelton, it appears those plates have been expired for 2 years. I looked down and said, yeah, as a matter of fact, they have. But as I understand it, you can't cite me for violating an Illinois law. And he said, that's right, I can't. But if I see that thing again here in Texas, I can cite you for violating a Texas law. Fair enough. Idaho police officer cannot cite you for violating a Texas law, a Washington state law. So have you been listening to the program up to this point?
I've been listening for about 2 months now.
Okay, well, did you hear the beginning of this show when we were talking about police officers exerting or purporting to exert an authority they don't expressly have? I don't remember the statute in Washington state, but I have seen it. There is a statute that reflects 18 U.S. Code 242. And that's we've been talking about. In Texas, it's 3903, official oppression. If a public official acting under color of his authority exerts or purports to exert an authority he doesn't have and denies a citizen in the right, that's a Class A misdemeanor in Texas. It's a Class A misdemeanor in the Fed, and it's been a Class A everywhere I've seen it. You will almost certainly have that in Idaho. And you certainly have it in the Fed, so you don't need it in Idaho. You can accuse him of violating 18 U.S. Code 242. Write that one down and then look it up. He exerted an authority you don't have. You're a citizen of the state of Washington. You're in Idaho. That's diversity jurisdiction. And it's a due process claim. So in order to get it in the Fed, you'll have to make a claim against them for in excess of $75,000. So you might as well make it 150, 200 grand and accuse them of a due process violation. And this is a good way to give them notice that they will wind up in the federal court with you because you say they violated 18 U.S. Code 242. The officer committed a crime against you, and that makes them liable to you under 42 U.S. Code 1983. That snatches them right out to the federal court, and they'll know it, and they know you'll file in Washington State. Hang on, Randy Kelton, Real Raw Radio. We'll be right back.
Easy.
Okay, we are back. Randy Kelton, Grooveball Radio, and we're talking to Spencer in Idaho. Spencer, does that sound like a fun plan?
That sounds like an absolute blast. It really does.
Yeah, they won't even see that one coming. That citation for registration, that is wonderful.
Yeah, I'm looking at the actual citation here. They have driving speed 1 to 15 mile per hour exceeding the maximum posted speed limit. Vehicle registration, failed to register annually, and failed to provide proof of insurance. And
both of those are Washington State offenses because you're registered in Washington State.
Idaho code cited here, but
you're registered and you're a resident of Washington State. You're not subject to the state of Idaho's administrative codes.
Yeah, but the total fine they put on here, they put letters in here rather than numbers. So the fine is C. They have a dollar sign and then C, letter C. It's not even a dollar amount. I find interesting why or how they do that.
Well, find out how much it is. It costs about $250 to file in the Fed. And almost certainly this thing, you probably won't even need to get there if you send them a tort letter.
Yeah.
Once they see the tort letter and see that he cited you in Idaho for violating a Washington law, they're going to say, uh-oh. And now if they try to prosecute you, they've already subjected you to the due process violation. Good chance they'll dismiss the whole thing to keep from being sued. Everything's political,
wrote this.
And politics always follows the money. Okay, does that pretty well handle it?
That certainly handles it.
Okay, and kind of keep us up to date. Hey, let us know how this works out.
I will do that.
Okay, thank you, Spencer. We got 2 more calls, and we're on our last segment. Going to Larry in Arizona. Hello, Larry. What do you have for us today? Larry, you still there? It looks like we've lost Larry. Okay, we are going to Rob in New Mexico. Hello, Rob.
Hello, Randy. How you doing?
I'm doing good. How are you?
Well, I think I'm doing good. I've got everybody either answered or moved to dismiss in my 2 state cases. The seller, who I allege breach of contract and fraud and all kinds of other stuff, they filed an answer and counterclaim. They claim to be without sufficient information regarding my jurisdictional claims. Their counterclaim does not contain a jurisdictional statement.
Whoa, hold on. They're saying they don't have information to establish jurisdiction?
In their answer, based on my complaint.
Then you need to file for summary judgment.
Let me tell you what else they did. So they claimed in their answer that they're without sufficient information regarding my jurisdictional statement, and then they didn't include one in their counterclaim. Their counterclaim does not contain a statement of facts. Their counterclaims names me and my wife, but they did not serve my wife, and the certificate of service only names me. My wife is not a party to the suit as a plaintiff.
Wait a minute. Is your wife on the mortgage?
She's on the contract, yeah.
Okay. That makes their claim lack subject matter jurisdiction.
Yeah, they name her as a counter defendant in their counterclaim, but they did not serve her.
Oh, okay. So they did name her in, so she was included, but they didn't serve her.
Yeah, and I'm the only person named in the certificate of service. So basically, I'm guessing.
Okay, you probably will lose that one.
Okay.
Because the court is going to say, do you live with your wife? You can say yes. Then reasonably, she has constructive notice.
Okay. So they don't need to actually serve her or even name her in the certificate of service.
Well, the law kind of technically requires it, but the court has a certain amount of leeway. They're not going to deny someone their remedy over a technicality that does not go to the substance of the case.
Okay.
Because they would ask her, did your husband tell you that he had received this summons or this service? And she's going to have to say, well, yeah, I knew about it. Then you have constructive notice that you won't win that one. Okay.
Now, they allege in their counterclaim that I'm a resident, and they allege civil violations. Not aware of being a resident, and I'm not aware of any civil laws that would apply to me outside of trucking.
Okay, resident, complex equivalent. What do they mean by resident, and what do you mean by resident?
No, I have no idea what they mean by it.
Okay, then you might want to ask for clarification.
Okay. And then
generally, resident would mean that you're an occupant of the property.
Mm-hmm. Okay.
And that you live within the state. It depends on the context of the use of resident.
They allege that I'm a resident of the county, and my understanding was that means I'm an inmate.
Wait, that means you're a what?
An inmate?
No, it doesn't mean such thing.
No.
It means you reside in the county, that your domicile is within the county.
Okay. Now, there are allegations of breach of contract. That comes subsequent to my notice of rescission, and that comes subsequent to my notice of seller's default filed in the county records.
Okay, then you have to win the claim on rescission. If you win that one, then you'd move for summary judgment on the rest, because then they would be moot.
Basically, it has to wait to hear their breach of contract claim until mine's done. Then. Is that correct?
Well, yeah, you have to answer. Make sure you answer those claims, even if you think you won't get to them, because the court's likely to rule against you on the rescission, and you're going to have to adjudicate it in the Court of Appeals. So in case you get ruled against on that one, you want to make sure you have a defense to the others.
Okay. And you don't see anything for a challenge to subject matter jurisdiction here, do you? No lack of standing or anything?
Well, I'm not clear on how did you claim lack of jurisdiction when you're the plaintiff?
Well, yeah, that's what I'm questioning. I did do that on the fake servicer because there's no assignment to them and they're not named in the complaint. So their counterclaim was simply for legal fees, attorney costs based on the indemnification clause. And I said that didn't apply to them and that they're not a named party to that contract. And my complaint against them is simply based on their Unfair Practices Act.
So essentially, if their petition is frivolous, you should move for sanctions against them. If it's clear that they don't have a right to attorney fees in this instance, then you should go for sanctions.
Okay. And they wouldn't, would they?
Okay, so they're not like you. You're just an ignorant old truck driver, so you're not held responsible for knowing this. They're learned counsel. And it doesn't make any difference if they're ignorant learned counsel. They don't get to claim ignorance. They don't get to claim a mistake. If they filed a request for attorney fees when the law was clear that they didn't have a right to them, that's a frivolous pleading, and that should get them sanctions.
Okay, well, let me ask you this then. Is there any lawful means under which a named servicer can ask a successor servicer to, quote unquote, step in, absent an assignment, after default, and that subsequent servicer obtains indemnification rights?
Yeah, there is a way if he makes the servicer a agent.
Mm-hmm. Well, they're claiming that they're agent.
Okay, they can do it as an agent.
But what evidence of agency do they have?
You could ask for evidence of power of attorney.
Mm-hmm.
They would have to have a durable power of attorney in order to act in the name of the present servicer. Would have to grant the new servicer power of attorney.
So just a letter saying we're asking you to take over is not sufficient?
I'm not sure. Does it have to be? No, that wouldn't be sufficient. There'd have to be an underlying contract.
Okay, excellent. All right, Randy, thank you very much.
Okay.
Good night.
Okay, thank you. We're out of time. Thank you all for listening. Randy Kelton, Rule of Law Radio. We'll be back next week. Thank you all for listening, and good night.